So, as I said, welcome to this webinar on freedom to operate. My name's Philip Webber. I'm one of the partners in the Life Sciences Group at Dehns. So, over the past few weeks, Dehns has given a number of webinars on various aspects of patenting your inventions and also on trademarks and designs. But most of them have been talked about patenting your inventions. But today we're going to talk about the other side of the coin. So we're going to be talking about your competitors' patents and what they can do to possibly stop you exploiting your invention, whether you've got patents on them or not. So if you have any questions during the course of my presentation, you can enter them using the Q&A button, and I'll try to deal with as many of them as I can at the end. So, as I said, there are two halves to patents. There are your patents. So the issues there are whether your inventions are novel, whether they're inventive step, what's in the prior art, what's in the public domain that might be relevant to whether your inventions are novel or inventive. And I say we've talked a lot about that over the last couple of weeks. But there's another side to the patents as well. So the other side is your competitors' patents. And if they get patents, what can they do to stop you putting your product on the market? So here we've got a totally different set of issues. So here we're talking about what is the scope of their patent claims? What do they actually cover? What countries have they got patents in? Are those patents still in force, or are they dead? Or indeed, are those patents valid? And so it's very important to keep these two issues totally independent, because they are independent. Even if you've got patents, that doesn't mean you can ignore other people's patents. And so this seminar is going to be looking at sort of different issues that we have been talking about in other webinars. So we're talking about freedom to operate. So the basic question here is that if I've got a company, or if I'm setting up a company, does anybody else have any patents that can be used by them to stop me doing what I want to do? That is sort of selling my product or making my process or something like that. More specifically, freedom to operate is about finding whether there are any other people apart from you that have got valid patents, that is ones that are properly novel and inventive, that are in force, that is not patents that have already died after their 20-year life or they haven't paid renewal fees. Do they cover the product or the process that I'm interested in? So we need to look very carefully at the claims of the patent application, and we need to find patents that are in the countries that are relevant to us, that might be used to stop us exploiting the process. And so during the course of this, we'll hopefully understand why it is so complicated, why it takes so long, and why it can in fact be quite expensive. So, but before I start, I just need to do the legal bit, saying, I'm going to give you a sort of basic rundown of freedom to operate today, but there are a lot of issues that I won't have time to talk about. So I want to try to sort of guide you through the middle of this sort of complex maze. But if you do have any specific questions, then it is vitally important that you talk to your patent attorney about this and get some proper advice. So this is a summary of what I want to talk about. I'm going to start off with dealing with a few misconceptions just to make sure that everybody understands those properly and there's no confusion there. We're going to remind ourselves about what rights the granted patent will give to you or your competitors in this particular case, and what they can get out of you if you are sued for patent infringement. So once we've dealt with those, we will then look at the freedom to operate process. And that has basically three parts to it. First of all, you need to do a search to find the relevant patents that are out there. The second part is to analyze the results of that. And then once you've got those results, what are you going to do about the information that you found? So first of all, as I've mentioned right at the start, a lot of people seem to think, right, I've got my own patent, that covers a particular product, I'm okay, nobody else can have patents on that. Unfortunately, that's wrong. If you look at the example here, say you're the first person to invent the electric car. So you could file a patent application for that as long as it's novel, it's inventive, and you can get patents granted for that. And so you might think, right, well, I'm free to make electric cars, other people won't get patents on that. But if somebody has already got a patent that covers all cars, then your electric cars will fall within their patent. And so while their patent is still alive, you can't make your electric cars. And so the point that I want to raise here is that even if you've got your own patents, that doesn't give you any right to ignore other people's patents. And so certainly for the context of the freedom to operate, ignore the fact that you've got patents. They are irrelevant to whether anybody else has got any other patents, and you need to worry about those. So forget about any other patents that you might have. We're not talking about those today, and those are irrelevant. The second issue is that I've had over a number of years, sort of number of clients phone me up and say, panic, panic, we found this patent that covers that our competitors have got, and it covers our product, and we're just about to launch this in the market, and yeah, panic, panic, they're going to stop us from doing that. And I say, whoa, let's hold on a minute. Do they have a patent, or is it a patent application? And I appreciate it's not always easy to see from the face of patent documents whether it is a patent or a patent application. The one that I've got on the screen here, that's an international patent application. And those international patent applications will always be will always be applications. There is no such thing as an international patent. So if somebody says to you, oh, I've got an international patent on this, they're talking rubbish. So, but look at these documents carefully. Does it say anywhere that the patent has been granted? And if you look at the case here, you can see that it's got an international filing date, it's got an application number, but there's nowhere on this document that said it's a granted patent, because I say there is no such thing as an international patent. So international patent. On the contrary, the documents that I've got here, the top one is a US patent, and it says clearly United States patent. We have a patent number and the date of the patent. Similarly, the bottom one is a European patent specification. It has the date of the grant over here, and it's got a grant number. And certainly as far as United States patents and European patents, the numbers are followed by a B. And so if it's got a B on it, as far as it's United States and Europe, that will be an indication that it's a granted patent. And so then you do need to worry about them. Whereas patent applications, I mean, anybody can file patent applications for anything, but it's only once they've been through the examination process and the examiners have confirmed that the claims are novel and inventive, then that will give you the rights. Nobody has rights to enforce a patent application against you until it's actually been granted. So with those misconceptions taken out of the way, let's look at what are the rights that a competitor might have if they get a granted patent. So these are the rights on here. They will have the right to stop you making, using, selling, or importing a product or process that falls within the scope of their granted claims for up to 20 years from the filing date of their patent application, not the priority date, from the filing date. So these are the sort of things that they might use their patents to stop you doing. If they sue you for patent infringement, what are they going to try to get out of you? First of all, they will try to get an injunction. That's basically a court order saying, stop, you're not allowed to infringe their patent anymore. And specifically, they're going to want money out of you. Money either based on the losses that they have incurred because you've been taking their market out of them, or if they haven't particularly lost much money because their sales haven't gone down, but they can see that you've made a lot of profit out of the invention, they can get an accounts, and they look at your profits and say, right, we claim that amount of money based on the profit that you have been making. And of course, they will try to claim their legal costs. So they will have a legal team of solicitors and barristers charging them lots of money, and so they will try to get that money back from you if you lose on the patent infringement case. Of course, from your side, you're going to have your own legal team, and they will cost you as well. And so if you lose the patent infringement case, then you're going to still have to pay your own legal costs. Also consider things like, the publicity that cases that are like this might have against you, and also the effect that it might have on your investors, on your shareholders as well. So really, you don't want to get a patent infringement case unless you can really avoid it. So you set up a company, or you're already at a company, or you're making a product or a process. When is the best time to start freedom to operate? Now, I've had over the years a number of clients come to me and we say, we've had this idea for a new invention, and we haven't made it yet. We don't know exactly what we're going to do yet, but can we do a freedom to operate on it? And I say to them, well, it's actually very difficult to do a freedom to operate search looking for specific patents if you've only got a very vague idea of what you're actually going to be producing at the end of the day. it's much better to wait until you've got some sort of reasonable concept of exactly what you want to put on the market. Because until that time, you could do a search, covers all sorts of different areas. You could be analyzing lots and lots of different patents and patent applications. You can incur huge costs. And in fact, if you haven't decided yet what you want to do, then it might in fact not even cover the product that you want to put on the market. So I would say, my personal recommendation would be to wait until you've got a reasonable idea of exactly what you want to make, what you want to sell and put on the market before you actually do a freedom to operate search. There are things called patent landscaping, which you can do at an earlier stage, looking at areas where lots of patent applications have been found. Lots of patent applications have been filed, and they give you pretty contour maps of, lots of patent applications in this area, not so much in this area. And that can give you an indication of the hot areas that are being developed. But it doesn't necessarily give you much information about whether they might cover your particular product that you're interested in. So my personal recommendation will be to wait until you've got a reasonable idea of what you want to do, what you want to put on the market. And certainly if you're about to make your product and about to put it on the market, then certainly you need to be looking at freedom to operate, at least by that stage. So the first stage in the process is to commission a search. Yeah, we need to find the patents that are out there. So the things you need to think about at the starting point are listed on the slide here. It certainly helps if you know your market and your competitors, because we can give that information to the patent searchers and say, look, particularly look for patents in the name of company X, company Y, because we know that they're active in this area. You need to think about, how broad does your search need to be? How can you define your product or your process? What countries do you need to cover? Where are your main markets going to be? Do we need to look at both patents and patent applications? And how rigorous, how rigorous does your search actually need to be? And we'll look at those in the next couple of slides. So first of all, how broad is your how broad is your search going to be? As I said, if you've only got a vague idea of what you want to put on the market, you're only going to get you're going to have to do a broad search. You're going to find lots of hits in the patent databases that might be irrelevant. Your patent attorney is going to have to spend a lot of time going through these documents, and that's going to be expensive. And if it's only a broad search, will it in fact cover your final product? Are you wasting your money because actually you're going to have to do a further search later on once you've actually defined what your product is? On the other side, you might find that there are key patents that are going to be problem patents, and you're just not going to be able to overcome those. And it might be better to find those sooner rather than later. On the other side, if you do a narrow search, you know exactly what you want to put on the market, or at least you've got a reasonable idea. The search is going to be more focused. You're going to find fewer hits, but they're going to be more relevant ones. And your patent attorney is going to waste a lot less time because they're going to be focusing on the sort of key issues that are relevant to you. On the other hand, it might be quite a late stage that you find some problem patents that you just can't overcome. So there are swings and roundabouts for both, but I personally would sort of point you more towards doing the sort of narrow search once you've got at least a reasonable idea of what your product or process that you actually want to make or sell is. So here we've got a simple case study here. So you're part of a company and you're making compound C, and you're using it to treat malaria. I came up with this example a couple of weeks ago. Hydroxychloroquine was very much in the news there. So we've got a company that's taking two compounds, reacting them together under certain conditions, and making a third compound and selling it to treat malaria. So that is the rationale for the company. That is what they're going to be doing. In terms of freedom to operate, what do they need to worry about? Well, let's just remind ourselves what the patent rights, if somebody's got a patent that covers any of these products or processes, what can they stop you from doing? They can stop you making, using, or selling any of your products or processes. The ones that have got patents granted are for up to 20 years. So let's look back at our process here. So in terms of compound A, we are using compound A in this process. If there's a patent on compound A, then using compound A will be an act of infringement. We need to find patents that cover A. Similarly, if we are using compound B, we need to find patents that cover that, because use of compound B would be an act of infringement. The compound C that we are making and selling, as I said from the previous slide, the making or selling of a patented product is an act of infringement, and therefore we need to find any patents that cover C as well. There might be process patents that cover the reacting together compounds A and B to make C. There might be method of treatment patents that cover the use of C to treat malaria, and so we need to find those as well. So whereas initially we were thinking, right, well, all we need to do is a freedom to operate search on the compound C. In fact, when you think about it, we are using these other products as well, so we need to expand our freedom to operate searches to cover all of these other areas as well. So let's look initially at searches on compound C. Yeah, we've got this chemical compound, hydroxychloroquine. Right, well, let's do a patent search on that. Let's stick hydroxychloroquine into the patent databases and see what we find. Well, actually, we've got to do a lot more than that, because hydroxychloroquine is also known as oxychloroquine or oxychloroquine, and it's actually got some horrendously long two chemical names, so we're going to have to do searches on those as well. Hydroxychloroquine is also known by the trade name Plaquenil, and so we're going to have to do a search on that. If we're looking for patent applications, they might, or patents that cover hydroxychloroquine, they might not refer to it by name. So they might only refer to it by structure. So we've got to somehow search for patents that refer to it by structure as well. Or indeed, it's sort of chemical class, a quinoline derivative. So whenever you're doing these patent searches, you need to think very much, this is the product that I want to make. How might a patent attorney have defined that in a patent application or a patent? And we need to do searches to cover all of those different areas, because unless we get all the patents that cover it, there might be still one patent out there that's going to stop us doing what we want to do. So that applies to hydroxychloroquine, but it also applies equally to compound A and compound B. We're going to have to do similar searches on those just to check that nobody has patented those products. And also, as I said, processes of using A plus B to make C, and also method of treatment patents of using C as well. So you can see where, when you sit down and analyze the situation, a freedom to operate search can quite rapidly balloon into sort of something a lot bigger than you thought it initially might be. So we've defined our product. The next thing we need to think about is, what countries do we need to look for in terms of patent applications? Now, this is dictated by, where are you going to make your product? If you're only going to make and use sell your product in the United States, then you need to be looking at United States patents, and possibly you can ignore any other patents throughout the world. But if your market is going to be United States, Europe, and Japan, then you're going to need to be looking at patent applications in those countries at least. Now, in terms of searching the databases, it's relatively easy to look at English language databases, particularly of European patents and United States patents and international patent applications. Those are all available in readily accessible databases. But if your market is Japan and China, then we need to be looking at Japanese patents and Chinese patents. And so somebody needs to be able to read Japanese and Chinese in order to find out whether those patents cover the product or process that you want to make. And so that means your costs are going to go up quite a bit, because we're going to have to employ our colleagues in Japan and China to do searches in those countries as well, in order to find patents of relevance. As a sort of interim measure, there are quite often abstracts or rough machine translations available of patent applications and patents in those countries. And so we can do that as an initial start without having to look at the full translations. So next question is, how deep do you need your search to be? If you're a company, you're about to put a product on the market, then essentially you need to find all the patents that might be relevant to whether you can do that, because any one of them might stop you making or using or selling your particular product. On the other hand, if you're a new company, you just want to sort of a toe in the water, perhaps your investors need you to do an FTO because of part of their due diligence and things like that. There is also available what's called a cursory FTO search, where you just spend maybe a certain amount of time looking at the patent databases, and that might only find the main patents, but not necessarily all of them. Now, these cursory searches, obviously, because they're not totally exhaustive, they are a lot cheaper than exhaustive searches, but you have to be aware of their limitations. And certainly, I found that it's very useful to talk to the searching companies that do these sort of searches, and you can have a discussion with them. Quite often I've phoned them up and said, look, I've got a client who's got £1,000 to spend on a freedom to operate search. What can we do for them? And they come back and said, right, okay, for £1,000, then we're not going to be able to search patents in Japan and China, but we can search the main databases, and we can, for that amount of money, we can spend half a day or a day looking for relevant patents, and we will probably find the main ones, but it won't be an exhaustive search. But you can talk to the searchers and get agreement with them on the best that we can do for you. Certainly within Dehns, we generally use external searching companies because we know that they are specialists in their particular areas. I know there are other patent firms that have searching departments within the company, but they're never going to be specialists in all different areas. And so at Dehns, we go to the specialists who know a particular area and will do a particularly good job in that particular area. So I've talked about both patents and patent applications. Do we need to search both patents and patent applications? Well, the answer is yes, you do, because patent application might mature into a granted patent, and then it's a problem for you. But whereas in the granted patent, if you look at the claims, they're pretty much fixed. I mean, in terms of, we know pretty much that the claims aren't going to get any broader than that, because it's a general principle of patent law that once a patent claims have been granted, then you cannot expand the scope of those patent claims after grant. I've put a little asterisk on the slide here because I know in the United States you can expand the scope of the patent claims within 2 years of them being granted in the United States. But as a general principle, you cannot expand granted claims once they've been granted. In any litigation, they might be sort of narrowed, but also do look out for sister patent applications. Because they might have sort of overlapping claims in the same sort of family. Excuse me just a second, I need a drink. That's better. Right, so patent claims, they're granted, they're pretty much fixed. But patent applications, they're still going through the examination process. We don't know whether they're novel, we don't know whether they're inventive, and so they're a bit like a sort of cloud of smoke. You don't know exactly what their final form is going to be. So how can you judge whether a patent application is going to mature into a granted patent that's going to be a problem for you? Well, first of all, you can see whether the patent offices have already done a search on that patent application, or whether it's partway through the examination process. So if they've done a search on the patent application already, the examiners might say, right, well, I think these documents, A, B, C, and D, are relevant to the patentability of this invention. And so we, as the patent attorneys, can go through those documents and we can say, right, in the light of those documents, we can give you an opinion on what the ultimate claims are likely to be, based on our experience and our sort of knowledge of looking through those documents. But if the patent applications are at a very early stage, they haven't even had a search done yet, we might have to get our own search done in order to find any relevant prior art documents, and then we can make our own assessment as to whether that patent application is going to mature into a granted patent that might be problematic for you. But I say, looking at patent applications as well, which you have to do, it adds another level of complexity into the whole process. So you've done your search, the results are in, you need to start looking through each of the documents. How are we going to start doing that? Well, the first thing to look at is, is the patent still alive? Is it in force? If it's beyond 20-year life, then the chances are it's going to be dead, because most patents these days have only a 20-year life. Have the renewal fees been paid in order to keep it in force every year? If they haven't been paid and it's been allowed to die, then we can ignore that patent. It's not relevant. We need to look at which countries the patents have been filed in. Generally, they come back, the results come back in patent families, saying that this patent family is based on a particular invention. It has been filed. There are patent applications in the United States, Europe, Canada, Australia, Japan. And so which ones of those are relevant to your particular markets? But then somebody, normally the patent attorney, has to sit down with the pile of documents and just go through them one by one, comparing each of the patent claims against what you want to do in terms of selling your product or process. So, right, claim 1, does that cover your process? Claim 2, does that cover your process? And in each patent, there might be, I don't know, 20, 30, 50, sometimes 100 different claims. And so the patent attorney has to go through each one of those, comparing it to the product or process and making a decision. Yes, that covers your product. Then that's a problem patent. Red lights. It's, quite often they will be, well, maybe there might be some words in the patent claim that you don't know how are going to be interpreted by a court. And so you might have to go through the description section of the patent application, which might say, as used herein, the term blah, blah, blah means this. And so using that definition from the description, does that cover the product or process that you want to make? And so, and if you've got long patent applications, yeah, some patent applications that I deal with, yeah, 100 pages long. So the patent attorney will have to sift through all of that information in order to see, yeah, is there any relevance? Is there any relevant part of the description section that might have a bearing on the interpretation of how the patent claim is interpreted? And certainly in the United States, they have something called file wrapper estoppel, which means that if the applicant made a statement during the examination of the patent application, say for example, that in order to convince the examiner that the claims were novel, they said, well, this term clearly means this. And so if the patent attorney has made such a statement in the US Patent Office, then that can be held against them basically when the patent claim is being interpreted by a court. So there are issues that have to be resolved about how the patent claims are interpreted. But at the end of the day, yeah, they will come out with a list and saying, yes, these claims cover the product or process. Maybe we need to look at things further, or no. And then remember that even within a patent family, you might have a patent that's granted with broad claims in the United States that do cover your product or process. So you've got a problem there, whereas there might be narrower claims that are granted in Europe. And so that might not be a problem. And so you need to look at the different patents in different countries as well. But at the end of the day, this is the sort of analysis that you would expect to receive in terms of your FTO results at the end of the day. So a list of the patents, where their countries that have been filed, the expiry date will give you an indication of how long a life the patents have got to be, which claims are relevant in those patents, some comments, and then one way of certainly breaking them up, and that a lot of people use, is this sort of traffic light system. Red patents being particularly problematic ones. Amber ones, yeah, we're not sure about yet, possibly need to monitor, and green ones that we know are not relevant. So for example, looking at the top of the US patent there, you see it's got an expiry date of 2025. And so it is relevant, but how long are we going to actually take to get the product on the market? Can we wait 5 years or so? If we can, then perhaps this top patent will not be relevant. The second patent is a granted European patent, and we've looked at European patent registers, and it has been brought into force in Britain, France, and Germany. Again, it has claims that cover our products, and it has still a maximum of 9 years life on it, and so it's again in the red category. The third one is an international patent application, and we found out that patent applications derived from it have been filed in Europe, United States, and Japan. But I say, we've looked at that it's potentially relevant. It covers the products at the moment, but we've had a look at the search report. There's some documents that have been cited, and we believe that the claims will probably have to be limited, which to such an extent that it might not cover our product. But we don't know yet. And so we will have to monitor the progress of the patent applications through the European, United States and Japanese patent offices in order to keep an eye on it and to look again when the patent has actually been granted, to reassess at that time whether it's going to be a problem or not. The UK patent on the bottom there, you'll see actually its expiry date is October 2020. So it's only got another couple of months, yes, to live. So as long as you're not planning to put your product on the market for another couple of months, then you're okay. You can ignore that one. And the United States patent at the bottom there, we've looked at the claims, even though it's found in the search, we don't think it's relevant, so we put that in the green category. So this is the sort of example of the results you get at the end of the day. And depending on the breadth of your search, you might be 100, 150 different entries, each of which your patent attorney will need to categorize and to decide on appropriate actions on each of those. Whereas if your search is more focused, then obviously you will have a much sort of smaller number of patents to worry about at the end of the day. So how long will the FTO take? Well, I hope you'll understand, from the comments that I made over the last sort of minutes, as to why it can take sort of a reasonable time to do these things. Certainly, the discussions with the searching companies and things like that, resolving exactly what you want the search to cover, defining your products. Generally, they take a sort of week or two to sort out, and then we can commission a particular search. And you need to allow generally at least a week or so, 10 days for the searchers to do their job. But then how long is it going to take to analyze the hits? Well, that really depends on how many hits you get. I mean, if you've got a pile of 100 patents, then it's going to take quite a bit of time to go through those. I remember a number of years ago, I did a big job for a pharmaceutical company that was putting a new vaccine on the market. And they'd already done the search, and they basically sent me 100 patents to go through and say, right, this is the vaccine that we want to put on the market. Is it covered by any of these patents? And I just had to go through, read through the patents. It was in the old days when you looked at them on paper format. Just had to read through each of them and each of the claims. And it took me 2.5 weeks to get through all that. Because you have to painstakingly go through each one of them. And in the knowledge that if you miss one, then they could be putting this product on the market. It could cost them sort of millions to do that. And if I missed a patent, then any one of those missed patents could be used to sue them for patent infringement. So it is an important job. And so please allow time for these things to do. I know quite often when you're setting up a company and the investors are doing their due diligence, they will say, oh, we need an FTO search. Can you do it tomorrow? No, we can't do it in a day. As I said, hopefully you understand now why it is quite a complicated process, and it takes time, and you need to allow time for those sort of things to do. Second big question, of course, is how much is it going to cost? It's obviously a very important question. If a cursory infringement searches, if it's a sort of toe in the water, a quick and dirty search, you can sometimes get those done for £1,000 to £2,000. But if you're looking for an exhaustive search where you want to make sure that you cover any patent that might stop you putting your product on the market, then you're easily talking sort of £5,000, £10,000, £20,000, depending on the number of hits that are found within the database. And of course, you won't know that information until you get the results back. So you've got the results. What are you going to do about it? You could just ignore the results. I wouldn't recommend that by any means. If you find patents that are particularly relevant, blocking patents, then you need to think carefully about stop infringing at that point in time, because otherwise you have a serious risk of being sued for patent infringement. One thing you can do is, knowing the scope of your competitors' patents, you can design your product so that it does not fall within the scope of those patent claims. An alternative is to wait for the patent to expire, as I showed on the table. Patents generally have a life of 20 years. If you've got patents that are just about to expire, then perhaps you can wait until they have expired, and then you'll be much safer to put your product on the market at that point in time. There are some proactive things that you can do. You can apply to your competitor for a license underneath their patent. but be aware that they are not obliged to give you a license. If they want to keep the patent to themselves, they want to exploit the market themselves, then they do not have to give you a license. Alternatively, they might have American patents and European patents. They might want to keep the American market to themselves and not be prepared to license there. But if you're in Europe and you want to make your product in Europe, they might be prepared to license you for the European market only. If you do have patents on your own product, and say this is the one case where you can consider your own patents, and you find somebody who's got sort of related patents, you might enter into an agreement with them where you cross-license. They want to make your product and you want to make the products of their patents, and so you reach some sort of cross-licensing agreement to the benefit of both parties. Alternatively, if you've got deep pockets like Google or Amazon and you find a problem patent, well, just buy the patent or just buy the company. There are also other things, more aggressive things that you can do. Even after patents have been granted, if you ever end up in court and things like that, then you will have the right to challenge the validity of the patent. So basically, even if the other side proves that you are infringing the patent, you will be able to counterclaim that the patent should never have been granted in the first place. So if you can prove that the patent lacks the patent claims lack novelty or lack inventive step, then even if the court decides that you infringe the patent, you could try to knock out the patent. So you can proactively do that. You can do that in the patent offices or courts in some countries, or even if you don't want to actually sort of take that action, be prepared to do that if you ever were sued. And so preparing for those sort of things is always a good idea. With regard to patent applications, say these are ones that haven't yet been granted, you can actually intervene in the patent process by writing to the patent office examiners and saying, look, this competitor's patent should not be granted because of these particular reasons. Yeah, we know that one of our inventors went to a conference and one of the competitors' inventors gave a presentation, and he actually gave away details of the invention before they actually filed the patent application. So the patent granted should not be valid. So say you can write to the European examiners or American examiners and saying, look, please don't grant this patent for these particular reasons because the patent would not be valid. So you can do that, and in most countries you can do that anonymously as well. So if you don't want to show your hand or you don't want to show who you are attacking your competitors' patents, we can do that anonymously. Within Europe, there's a relatively cheap procedure called an opposition procedure. So if you find a European patent that's been granted within the last 9 months, and you have to do this within that 9-month window, you can file what's called an opposition against the patent, and then you actually take part in legal proceedings at the European Patent Office. And these are relatively cheap because patent attorneys do that, I mean, as opposed to solicitors and barristers and things like that. And patent attorneys are actually the best people to do this because we deal with the European Patent Office day in and day out, and so we know the procedures really well. And so that is a relatively cheap, by relatively cheap, I'm talking sort of £5,000–10,000, that sort of amount of money, as opposed to a court challenge where you're talking sort of hundreds of thousands of pounds. And so it is relatively cheap from that point of view. So if you do find competitors' European patents that have been recently granted, do consider filing an opposition against them. So you've got your results, you've decided what you want to do with them. A few other sort of top tips here. First of all, that FTO search is a very valuable document that you don't want getting out the company. You don't want other people finding out that you've done an FTO search that says your product infringes these patents. And so do keep the results of the FTO search strictly confidential. Only circulate it within the company of the people that absolutely have a need to know. On the other hand, if you have got your own patent applications for that particular product going through the patent process, be aware that you might need to actually disclose that FTO search to the United States Patent Office in an information disclosure statement, because in the United States, if you have knowledge of anything that is relevant to the patentability of your inventions, your patent applications, then you have a strong obligation to disclose that to the United States Patent Office. So the FTO search that you've had done on the product might fall within that category, and so you might have to disclose it to the Patent Office. If you've got patent applications that have come up on your FTO search, do monitor them regularly, keep an eye on them, find out once they've been granted, intervene, file third-party observations if you want to, challenge them after grant, but yeah, do keep an eye on them, don't forget about them. And once you have put your product on the market or define exactly what your product is, do a top-up search and check that the people in the development part of your company haven't changed your product, that it's in such a way that it falls outside the searches that you've done. Development people have a nasty habit of doing that and don't tell the legal team of what they've done. And so do keep an eye on what your actual product is. So my take-home message is, yeah, be aware that patentability, so novelty, inventive step, your inventions, your patent applications are totally different from FTO, which is worrying about other people's other people's patents. Even if you've got patents on your invention, does not give you any right to ignore other people's patents. In terms of searching, yeah, I am very much of the in favor of, yeah, don't jump in too early. It's very difficult to patent a sort of nebulous cloud unless you know exactly what your product is or have a good indication of what your product is going to be at the end of the day. Do work with the searchers, have a discussion with the searchers to define with them exactly what your search parameters are. They know patent databases and things like that, and so they can provide some valuable guidance as to how best to look for patents that might cover your invention. FTO searches take a lot of time. Please don't sort of say to your patent attorney, we need an FTO search done and it has to be done by the end of the week. Hopefully from this presentation, if you've learned nothing else, you've understood it is quite a complicated project. It can take a significant amount of time. And so if you want a decent result, then you need to allow the patent attorney and the searchers a reasonable amount of time to do this. And once you've got your results, yeah, keep an eye on your competitors' patent applications. There are things to do to intervene where necessary, and be aware of all the different options there are. Yeah, designing around your product, waiting until the patent has expired, actively challenging the patents in the courts or filing oppositions. There are a number of different options out there. Hopefully you'll have a better understanding now of what's out there. And say, more than anything else, be proactive. Yeah, do your FTOs, find out about these patents. It's much better to find out about them in advance, be prepared for them, than to sit back, do nothing, and wait until your competitors sue you for patent infringement. You really don't want to be in that situation. So yeah, do your FTO properly and be prepared. Okay, and that's, I think, pretty much the end of my presentation. I'll see whether anybody's got any question. Actually, I'm going to have a drink of water for doing this. Okay, I can see there's a couple of questions come through. Oh yes, the standard one. I'm only making products for research purposes. Am I exempt from infringement of patents? Unfortunately not. There is, certainly in the UK and in a number of countries around the world, what's called an experimental use exemption. But this, in the UK at least, only covers if you are basically taking apart the invention to try to find out how it works, to try to find out some more information about the invention that is being claimed. But if you are using the product, or you are sort of making it or selling or something like that, that does not fall within the research exemption. So even if you're at a university, if you are using a laboratory reagent or something like that, you are not just taking it apart and finding out what it works, but you are using it, that is an act of infringement. And even if you're at a university, you might think, well, this is an academic institution, how can they sue us for patent infringement? Well, most universities these days have technology transfer departments that are trying to make money out of their inventions. And so you can't really say, well, we're just an academic institution, but on the other hand, we're trying to make money out of our own patents. It doesn't work with the courts these days, unfortunately. So even if you're a researcher, you still need to worry about patent infringement. There's a second question here. If I'm already using a product that before somebody filed a patent application for it. Right, okay. So if you've been already using a product or a process, but you've pretty much been secretly doing that, and that is not in the public domain, then the patent, somebody could later file a patent for it, and that patent could be valid because it's novel, and because the claims of that patent would be novel and inventive over everything that's in the public domain. And so, but you've only been using it secretly. And so the question then arises that, are you still allowed to use it sort of secretly or do any more? Now, the patent laws, certainly in the UK, do allow you to do that, and you will not be sued, and you cannot be sued for patent infringement, but you can only pretty much do what you were doing before. So if you are using it for a particular, using a product which is later patented for make a particular process, and you are selling that, the results of that, then you can still do that. You will have rights that are preserved to do that, but you can't do anything more than that. And so you need to be quite sort of careful in those sort of circumstances. So I think time is pushing on, and so I'll answer the other questions offline. I will get back to each of you, I promise. Right, and finally, I'm going to hand back to Michelle, our marketing executive, with some final comments on the next sort of webinars that we've got coming up.